Hi everyone, my name is Roxana Soika. I'm a principal at Soika Law Professional Corporation, and I'm joined today by my art student, Chelsea Murphy.
Hi everybody.
And the purpose of today was Chelsea and I thought it would be very important to have a discussion that people can view with regards to income for the purpose of support, and that's within the realm of family law. So parties can seek either spousal support or child support from the other, and the income for each spouse can be artificially imputed by a court or through negotiations. And that imputation is based on a number of things. So I'll let Chelsea talk a little bit more about this, what she researched, and what were some of her surprising findings with respect to this.
So I did some research based on how many clients we have that actually ask questions about this. Essentially, income can be imputed when one party may not know the extent of their income, one party might not be fully disclosing their income, or might not be earning their full potential, all for the purpose of reducing the amount they have to pay in child or spousal support payments. So the imputation of income, as Roxana said, is when we artificially increase their income to reflect a more fair or proportionate payment for support.
Absolutely. And it's not, it is artificial increasing, but it really is not, because if you think about it, support is based on the before tax income. So it's not the money that you actually get in, it's just support is calculated based on that. And many clients think it's unfair that we calculate based on that, but it's just a calculation for everyone so that it should be kept consistent. So keeping that in mind when we look at people that make cash or people that earn an income that is not reflected on their line 150 or that's not properly reflected by what is on paper, we look at imputation of income. So having said that, after Chelsea's very good description of what we do and the situations we find ourselves in with our clients, I'm going to ask Chelsea a few questions regarding different types of situations and whether the income should be imputed or not. So let's start with cash income. You did mention that earlier. So just to clarify, is cash income, so income that is not declared, is it included and is it added back to someone for the purpose of calculating their income?
So this is actually the most common scenario, and the simple answer to your question is yes, it is included in the imputation of income.
Perfect. So it is included. The only question that most people have and concern is that if you are the party that's trying to impute the income of someone else, you don't know how to prove it. If you are the person who's making the cash income, you do not want that income to be included for the purpose of support. So there are a lot of considerations and evidentiary rules to take into account. There's a lot of forensic type almost accounting that the parties can do when it comes to disclosure and analyzing the financial statements of each party to determine whether it is reasonable to impute cash income. So I just want to expand on that. For example, as a litigation lawyer myself, some of the things that I do when it comes to litigating things in court, other than just disclosure, looking at people's expenses, at their lifestyle, and trying to impute income based on that, it's also a lot of evidentiary problems that arise. So for example, people don't know that evidence can be just viva voce evidence, so oral testimony. So my clients can testify in court to the fact that they saw their spouse working 12 hours a day, they saw they were never home, they saw they always had money even though their declared income was not that high. So these sorts of things can still be introduced in court. So this all depends on the experience of each party, the facts of the case. And most importantly, another aspect that we should mention with regard to cash income, let's say someone is making, it is proven that they're making an additional $20,000 cash income. That income will be grossed up for the purpose of support because, as I said earlier, it is the before tax income that we look at and not the actual money that they receive in their hands. So that is a very good technique to increase the income of the payor as much as possible. Moving on from cash income, as you see, a lot of these issues revolve self-employed people or people that could have the potential to be self-employed when making cash income, although it's possible to make cash income when you're employed as well. So the next one, when in a situation with people that are self-employed, are people that own corporations. So Chelsea, based on your research and your experience working here, can people hide behind the corporate veil when they own a corporation?
No, they cannot.
Excellent. And can you explain why based on your research?
Yes, so the general rule when it comes to the imputation of income and corporations is dependent on the money available. One of the general rules includes that money needed for the essential running of the business cannot be used for the imputation of income, but that the self-employed person also has an onus to prove the basis of their net income. And this also applies to dividends and people who own their own corporations. And as Roxana mentioned earlier, dividends can also be grossed up for the purpose of imputation.
Absolutely. So dividends can also be grossed up depending on, of course, who owns the corporation, what the taxation scheme is. But generally, dividends can also be grossed up. And in addition to that, as Chelsea mentioned, just to be more clear, when there's money in the corporation, so let's say you have a corporation and you pay yourself a salary or you pay yourself dividends, and then at the end of the day, at the end of the year, there's still money left in the corporation, we need to analyze that piece and see if it is reasonable that that money stays within the corporation or if it should be imputed as income. So it is very dependent on the facts of each case, and a deeper understanding of the disclosure has to take place before advice can be given on this situation. But any lawyer that's trying to do their due diligence would ask for all the information regarding the corporation, including expenses and all those sorts of things. And to talk about expenses as well, a self-employed person gets to declare a lot of expenses. Is that correct?
That's
so
correct.
We start from cell phone bill. We go to gas, to all sorts of things that a person that's employed might not be able to declare as an expense.
Yeah.
So those expenses, do they get imputed? Yes or no, or maybe?
Maybe.
That's correct.
Maybe.
That's correct. So I think everyone can tell from just my comments about that it really depends if those expenses are for the business, if they would incur without the business taking place. So for example, I think a cell phone would be quite reasonable in most scenarios to be imputed back because a person would need a cell phone regardless. But again, it depends on the nature of the business. So a family lawyer would have to assess that situation as well. Perfect. So, Chelsea, let's talk about, I know I touched on this a little bit when it came to cash. What about lifestyle in terms of evidence? Does the court look at lifestyle for the purpose of imputing income?
Mm-hmm. So this was one of the ones that surprised me the most, actually. In some cases, the courts have taken into account someone's lifestyle, and this generally happens when the lifestyle and the expenses that they do declare don't line up with the income that they've declared on their financial statement. So, for example, if someone declares $50,000 and we know that the rent or the mortgage that they're paying every month far exceeds what we know they can afford, the court can take into account their lifestyle to impute their income.
Yes, and the way that will be done, so for example, a person can still afford a very expensive rent if they're taking a line of credit, let's say, or they have a lot of debt with regard to that. So any expense has to be recorded somehow, how it is paid for that expense. So it's very important for people to understand that everything has to be logical and make sense. You can have many expenses. If they come from somewhere, if you're incurring a lot of debt for that, then it makes sense. But if you're just paying for them and we don't know where the pay is coming from, then we have to question, and it is possible that the court would impute the income. And as part of this process, we request bank statements, all sorts of information about income from the employer. It is a very tedious process, and I think it's very reasonable in most cases to ask for 3 years of disclosure.
Yes.
So I think it's very difficult to argue against that. So that's important to consider. Something very interesting that Chelsea researched, social media is one of the most important platforms for most people these days. And what happens when you post on social media about how much your income is, or you post a photo with a new car, or you post vacations that you take. What's the general view of the court on that?
So the general view of the court as of right now is that social media is not used to impute your income, because social media can often act as an exaggeration of your lifestyle and not an accurate reflection of it.
Absolutely. So I think it's still something that should be taken into account. It's also something that should be argued, even if maybe the case law consistently says that it's not good evidence to show lifestyle. But I think it's still something that parties should look at and take into account, because if you see your ex with a new car, you might want to inquire about that during the disclosure exchange process. So see, everything is very fact-based. There are answers, yes or no, but it really depends on the facts of each case, and you can still use that information. Would you not agree?
I totally agree. Everything I learned in my research was very case-specific. There are general rules, but as always, every rule kind of has an exception to it, and it always depends on the facts of the case.
Absolutely. And again, I find social media a very good place where to start the research, but and I think a lot of people have that question, so it's good that we cover that a little bit. One of the other things that I found fascinating, especially in my younger years as a lawyer and dealing with these cases, were gifts. So I think that's probably you found that very interesting and surprising, because I wouldn't have thought that gifts would be included for the purpose of support. So what is your view on this, Chelsea, based on your research? Are gifts received by one party from, let's say, friends or family, are those included as income for the purpose of support?
Sometimes yes and no, depending on the facts of the case.
Everything in law is sometimes, or it depends.
Sometimes it can be counted as excluded property, and sometimes it can be counted as an asset and therefore part of your income.
Absolutely. So that's with regard to property, just to correct Chelsea a little bit there. So gifts with regard to property, that's another issue. So gifts received during marriage are usually excluded for the purpose of property division. But what about gifts for the purpose of income? So let's say you received, let's say, a $50,000 check from your father. Will that be imputed to you as income for the purpose of support? What do you think about that?
I think that it can be imputed for the purpose of support, because you've derived a financial benefit from that check coming into you, and to not disclose it, if you have that wealth in your financial disclosure and your assets, then it should be applied to your spousal or child support payments.
That's a very good answer. So people should generally be wary when they receive gifts from family and accepting them or not. So the reason why I'm saying that is, in general, case law says that gifts that are received periodically and that are consistent, and gifts that are likely to reoccur could lead to a permanent imputation of income for some time, until there's a material change in circumstances. So the typical scenario would be where you reside on your own, you pay your own rent. Let's say your rent is $2,000 a month, but then your parents send you money every month for $1,500. They give you $1,500 every month to help you with expenses. In that case, it is very likely that your income would be imputed, and that $1,500 plus tax, grossed up for tax, let's not forget about that, would be added back to your income for the purpose of support. So gifts, people have to be very wary about gifts, and it's good that Chelsea mentioned the property part of gifts as well, because you should really be wary when you or your significant other receives gifts, because of the timing can affect property division, and also the timing of it, plus who it comes from, consistency can affect income for the purpose of support. So that's a very important one, and it's important to disclose to your lawyer, and to be very careful when it comes to analyzing your own situation and what's important for you. So definitely, I think this discussion showed why consultations are so important. If you are someone who's in this situation and you are very worried. Even ourselves right now, we cannot say for sure what would happen with gifts. We say it depends. But you just need to know that you should be concerned, or you should have the information for yourself when it comes to your own facts. Is that correct?
Yeah, absolutely.
So Chelsea, do you have anything else to add on this topic?
I don't think so. It was definitely a really interesting, complex topic. So I think that consulting a lawyer is definitely really important if you are going through any family legal issues, because it is a very complex, uncertain topic, and a professional would definitely help with that.
Definitely, I think complex is a very, very good word to use, because it is not a simple process. The process of financial disclosure is a very interesting one, and it requires a lot of expertise. So that's probably what you should take from this as well. And I hope that you found this very informational. If you have any questions, you can contact us at roxana@arsoikala.ca. Thank you so much.